again. So very happy again, always with you. And although, by the way, say to tell you how my name is pronounced. It's a strange name in my country too, MOUSTAIRA. So it's not but everybody gets confused with my name, so just to mention that. So I have the pleasure to chair the session about fundamental rights, which is one of the most delicate issues in the domain of artificial intelligence. And let me give the floor to Professor Ibrahim. Is it right pronunciation?
Perfect.
So please, we are all here.
Thank you very much, Madam Chair, Madam President. I would like to extend my special thanks to the organizers of this fascinating and very important international symposium on artificial intelligence and the law. Our title is the Council of Europe's Framework Convention on Artificial Intelligence, Human Rights, Democracy and the Rule of Law. We will be trying to make a critical approach from a human rights perspective. The presentation and the paper has been co-authored by me and my dear colleague Ayşe ÖZKAN DUVAN. First, the outline of the presentation, and we give some introductory information, background information. Then we will be focusing on the fundamental provisions concerning human rights. I'll try to keep it very brief, and then we will look at the limitations regarding the scope of the convention and human rights risks, and finally I'll be making some final remarks. Artificial intelligence technologies have become integral to nearly every aspect of our daily life, encompassing fields ranging from robotics and speech recognition to computer gaming, spam filtering, translation services, and public security, as I said, in our contemporary daily lives. However, the widespread use of artificial intelligence raises significant concerns regarding potentially irreparable harm and serious threats to the human rights, the functioning of democracy, and respect for the rule of law. Furthermore, the adverse impact of artificial intelligence on these human rights generates additional worries about the proper operation of democratic processes. Concurrently, the opaque nature of our artificial intelligence systems and the lack of accountability mechanisms for both concerns regarding respect for the rule of law, including principles such as legality, prevention of abuse of power, and judicial impartiality and independence. Consequently, there is an emerging necessity to address artificial intelligence systems within a legal framework. Many international organizations have developed legal frameworks for AI governance. These began with the Universal Guidelines for Artificial Intelligence, the OECD Artificial Intelligence Principles, UNESCO Recommendation on Artificial Intelligence Ethics, European Union Artificial Intelligence Act, the Council of Europe Framework Convention on Artificial Intelligence and Human Rights, Democracy and the Rule of Law, which is the subject matter of our panel. The convention opened for signature in September 2024, last year. It seeks to regulate the contribution of artificial intelligence systems to the technological innovation in a manner consistent with human rights, democracy, and the rule of law. In this context, the Council of Europe Framework Convention represents a pivotal milestone in this regard. The factor driving momentum toward a global AI treaty is the growing global concern that artificial intelligence poses significant risks in terms of fundamental rights and democratic values, as I just pointed. In 2022, the Council of Europe established the Committee on Artificial Intelligence to draft a binding legal framework on AI. This framework reflects the Council of Europe's fundamental mission to protect human rights, democracy, and the rule of law. Over 2 years, representatives from 46 Council of Europe member states collaborated with observers from non-member countries such as the United States of America, Canada, Japan, and Mexico, as well as participants from civil society and industry, to negotiate the text within the Committee on Artificial Intelligence. The resulting framework convention was opened on May 17, 2024, at the annual meeting of the Council of Europe's Committee of Ministers in Strasbourg. As of today, a total of 16 states and the European Union have signed the convention. The convention needs 5 ratifications, including at least 3 member states of the Council of Europe, to enter into force. Already the convention is not in force because there are not enough ratifications. The Framework Convention consists of a total 8 chapters. Chapter 1 sets out the object and purpose and the scope of the convention. Article 2 defines the artificial intelligence system to mean a machine-based system that, for explicit or implicit objectives, infers from the input it receives how to generate outputs, such as predictions, content, recommendations, or decisions that may influence physical or virtual environments. Artificial intelligence systems may vary in their level of autonomy and adaptiveness after deployment. Chapter 3 sets out the principles governing the implementation of artificial intelligence activities. It introduces the principle of equality and non-discrimination, human dignity, transparency, accountability, privacy, reliability, and safe innovation. Chapter 4 is devoted to the remedies and procedural safeguards, while Chapter 5 focuses on risk and impact management. Chapter 6 is related to the implementation of the Convention, and it includes Article 18, which aims to protect the human rights of disadvantaged groups such as children and persons with disabilities. Chapter 7 establishes follow-up mechanisms for the implementation of the Convention, and it introduced a mandatory monitoring mechanisms in accordance with Article 26. The Convention, in its preamble, acknowledges that artificial intelligence offers unprecedented opportunities to protect and promote human rights, while being concerned that certain activities may undermine human dignity and individual autonomy, human rights, as well as democracy and the rule of law. Therefore, the Convention aims to ensure that activities within the life cycle of AI systems are fully consistent with human rights, democracy, and the rule of law. In order to reach this object and purpose of the Convention, parties are required to adopt or maintain legislative, administrative, or other measures as appropriate. Article 4, entitled Protection of Human Rights, stipulates that each party shall adopt or maintain measures to ensure that activities within the life cycle of artificial intelligence systems are consistent with obligations to protect human rights is enshrined in applicable international law and in its domestic law. Under international law, states have an obligation to ensure that their domestic laws are consistent with their international legal obligations, including those under customary law and international law that are binding upon them. Under international human rights law, states have an obligation to respect, protect, and fulfill human rights. The fundamental requirement of this obligation is that they ensure that their domestic laws are consistent with applicable international human rights obligations. However, states are free to choose the means and methods of implementing their international legal obligations, provided that the result is consistent with these obligations. This is an obligation of result, not an obligation of conduct. In third chapter of the Convention, there is principles related within the cycle of artificial intelligence systems. The first of these principles is human dignity and autonomy. The principle that artificial intelligence systems must respect human dignity and individual autonomy is regulated by Article 7. The second principle is transparency and oversight. Adequate transparency and oversight measures are required, such as identification of content generated by AI and ensuring that AI processes are subject to human oversight in accordance with the context and risk. The third principle is accountability and responsibility. Those who develop or distribute AI systems should be held accountable for any negative impact on human rights. The fourth principle is the principle of equality and non-discrimination, which is one of the fundamental elements of human rights law. The Convention prohibits AI systems from engaging in discrimination. States are obliged to ensure that AI respects equality, including gender equality, and combats both direct and indirect discrimination. The prohibition of discrimination is recognized as jus cogens in global and regional human rights law. The fifth principle is the privacy and data protection. Privacy and data protection are human rights guaranteed by human rights instruments within the United Nations, European Union, and of course, Council of Europe. According to the Framework Convention, the privacy of individuals and the protection of personal data must be guaranteed within the life cycle of artificial intelligence systems in accordance with the applicable international data protection standards. The principle of reliability, established as the sixth principle, is complementary to the data protection principle. The principle of safe innovation, established as the seventh principle in Article 13 of the Convention, can be evaluated in the same context. The Framework Convention possesses a broad scope, yet the final text adopted introduced several significant exceptions and restrictions that limit its scope and application. The final stage amendments are the result of intensive negotiations and carry substantial implications for human rights oversight. Article 3 of the Convention delineates which activities involving artificial intelligence systems fall within its scope. Accordingly, state parties will be held accountable for human rights violations arising from actions by both public authorities and private actors operating on their behalf. This means, as long as not operating on a state's behalf, private sector doesn't fall within the scope of the convention. Divergent opinions have been expressed advocating for the exclusion of private sectors from this provision. However, to prevent gaps in addressing potential human rights infringements stemming from artificial intelligence technologies widely used across various sectors and possessing extraordinary growth potential, no distinctions should be made between public and private sector activities. This is justified by the fact that artificial intelligence technologies extensively employed by both government institutions and private entities have demonstrated potential to cause human rights violations in contexts such as social welfare distribution, preventive law enforcement services, healthcare developed through medical data recording, and targeted advertising based on customer data analysis. Fundamentally, the Convention establishes general obligations for states to ensure that AI systems are designed, developed, and deployed in a manner respectful of human rights and doesn't compromise democracy or the rule of law. However, its scope is limited by certain sectoral exceptions, namely those pertaining to AI applications in national security and defense, as well as those developed solely for research and development purposes. The first sectoral exception outlined in the second paragraph of Article 3 applies to activities concerning national security interests. This constitutes an exceptionally broad exception. Although the Convention mentions the necessity of compliance with the international human rights framework, it effectively creates a loophole through which states may evade their human rights obligations by invoking national security grounds. The second exception stipulated in third paragraph of Article 3 is research and development activities related to artificial intelligence systems that have not yet been made available for use. Although this exception is applicable, unless testing or similar activities are undertaken in such a way they have the potential to interfere with human rights, it nonetheless implies that the design and creation stages of artificial intelligence technology are not regulated under the Convention obligations. Additionally, Article 3, Paragraph 4, exemption for national defense represents a third exception that narrows the scope of the Convention by categorically excluding artificial intelligence systems and activities related to national defense from its scope. Just a few final remarks, if I am allowed, because I am warned by the Madam President. From a human rights perspective, the strengths of the Convention lie in its emphasis on ensuring that AI serves humanity, as well as its incorporation of safeguards such as transparency, accountability, and remedies throughout the artificial intelligence lifecycle. However, it is important to acknowledge that the Convention is not a panacea. Exceptions related to national security and defense exclude some of the most sensitive applications of artificial intelligence from the Convention's common standards. Despite these limitations, the Artificial Intelligence Framework Convention represents a significant advancement in integrating human rights protection into AI governance. And finally, apart from these exceptions, sectoral and private sector, by introducing a distinct and finally ambiguous terms within the Convention text, such as, in brackets, endeavor to provide as appropriate, where applicable, or in accordance with domestic law, may hinder the effective implementation of obligations outlined in the Convention. Thank you very much.
Thank you very much, Professor Daniel. I hope I did not seem very threatening. I have to keep the pace of this panel. And it's very interesting. This first convention, this first binding treaty, so rich. We can discuss perhaps afterwards some issues that could be very broad for interpretation, but the fact that already 16 states have signed is very optimistic. I think we can discuss it. So let me pass the floor to Professor Volkan, Assistant Professor Volkan on human dignity and the constitutional limits of algorithmic decision making. Thank you.
Madam President, dear guests, esteemed participants, first I would like to sincerely thank everyone who contributed to the organization of this important symposium. Today in this session on AI and fundamental rights, I wish to focus on what is perhaps one of the most philosophical, yet simultaneously the most practical foundation of this entire topic, human dignity. My presentation is titled Human Dignity and the Constitutional Limits of Algorithmic Decision Making. The rise of artificial intelligence in decision-making processes profoundly challenges the constitutional protection of human dignity. From predictive justice rules used in the US like compass in criminal sentencing to automated recruitment and healthcare triage systems, AI increasingly shapes outcomes affecting individuals' rights and lives. And this raises a critical question. Can algorithmic decision-making align with the constitutional imperative to uphold human dignity? My presentation argues that constitutional and international frameworks must impose substantive and procedural limits on algorithmic decision-making to safeguard human dignity. Especially high-stakes decisions, those impacting liberty, livelihood, or reputation must not be fully delegated to autonomous systems. Procedurally, individuals require rights to explanation, contestation, and human review. So, what is human dignity? Human dignity is often associated with Immanuel Kant and his famous imperative order. With Kant's own words, this requires acting in such a way that you treat humanity, whether in your own person or in the person of another, never merely as a means, but always at the same time as an end. Even when we translate this into Turkish, it's not very understandable, but this human dignity necessitates non-instrumentalization of persons, and it's situated in the central intersection point of human rights and artificial intelligence, as it is based on human autonomy. It encompasses multiple dimensions, but when we talk about algorithmic decision-making processes, non-instrumentalization, being treated as equal beings without unreasonable degradation, and ability to exercise personal autonomy or self-determination appear as the most relevant ones. Nevertheless, subjecting individuals to algorithmic decision-making threatens individuals' personal growth by objectifying them. Moreover, this mechanism makes decisions by profiling people in secrecy, accepting persons not individuals but rather a member of certain algorithmic groups, has the potential to manipulate individuals and due to its non-transparent nature may threaten personal autonomy. That's why algorithmic decision-making is closely related to the human dignity. Now I would like to give information about the regulations in international conventions and constitutions. Human dignity, according to the Article 1 of the Universal Declaration of Human Rights, all human beings are born free and equal in dignity and rights. As a reflection of this, human dignity is guaranteed explicitly in lots of constitutions. For example, German constitution begins with a powerful foundational article, which states that human dignity shall be inviolate. To respect and protect it shall be the duty of all state authority. Article 1 of the Constitution of Brazil also describes human dignity as one of the foundations of this state. You can also find any other examples in comparative constitutional law. But it's not a must or prerequisite to contain a regulation which makes explicit reference to human dignity to use this criterion in the legal system. For example, the US Constitution doesn't contain an article which regulates human dignity explicitly, unlike the German or the similar constitutions. However, this concept is used by the courts and by the Supreme Court on cases which require evaluation of rights and freedoms, such as Obergefell versus Hodge. And this case was about the marriage equality. Human dignity is regulated and protected not only by liberal constitutions, by the way, but also in non-liberal constitutions such as China. According to the Article 38 of the Chinese Constitution, the personal dignity of citizens of the People's Republic of China is inviolable. Insult, libel, false charge, or frame-up directed against citizens by any means is prohibited. On the other hand, international frameworks such as the European Convention on Human Rights and the EU Charter of Fundamental Rights recognize dignity as a non-derogable principle, yet their application to AI remains undeveloped. Regarding regulations on algorithmic decision-making directly, several international regulations attract particular interests. According to the Article 22 of the EU General Data Protection Regulation, or the GDPR, the data subject shall have the right not to be subject to a decision based solely on automated processing, including profiling, which produces legal effects concerning him or her or similarly significantly affects him or her. And exceptions to this rule is regulated in the same article as well. In one of its recent judgments given in February 2025, the Court of Justice of the European Union stated that Article 15 of the GDPR must be interpreted as meaning that in the case of automated decision-making, including profiling within the meaning of Article 22 of that regulation, the data subject may require the controller as meaningful information about the logic involved to explain by means of relevant information and in a concise, transparent, intelligible, and easily accessible form the procedure and principles actually applied in order to use by automated means the personal data concerning that person with a view to obtaining a specific result, such as a credit profile. According to this judgment, in the event of a conflict between a data controller's interest in protecting trade secrets, such as an algorithm, and the data subject's right of access, the controller must provide the relevant information to the competent supervisory authority or court, which is responsible for balancing the rights and interests at stake and determining the extent of the data subject's right of access to personal data. We also observe similar regulations regarding human dignity in recitals 28 and 31 and automated decision-making in recitals 10 and 53 of the EU Artificial Intelligence Act. Despite these comprehensive regulations aimed at protecting dignity and governing automated decisions, their practical application reveals significant gaps and problematic areas where human dignity is actively threatened. Human dignity, as I said, a cornerstone of modern constitutional orders, underpins rights such as equality, privacy, and due process. It obliges states to prevent arbitrary or discriminatory treatment and to foster conditions for personal autonomy. In some instances, algorithmic decision-making is gradually used to reach public goods and services such as education and healthcare or injustice mechanisms, and by this way, it affects directly way of owning and benefiting basic rights and freedoms. While recruiting people to the private sector or to public offices, algorithmic decision-making process could be useful to prevent clientelism and nepotism. Thus, it can efficiently contribute to the employment of merit holders. Nevertheless, it can also function the other way around and could be the principal actor for discriminating people. There is persuasive evidence confirming that AI systems consistently aggregate bias rooted in historical datasets. Since many AI systems operate as opaque black box models, limiting transparency and human oversight, this opacity undermines individuals' ability to understand or contest decisions that shape their legal and social realities. Moreover, data-driven algorithms often amplify social biases, producing discriminatory outcomes in areas like employment, credit scoring, and law enforcement, thus reducing individuals to mere data points and eroding their dignity. Now, I will just give you some examples regarding these threats. First, the correctional offender management profiling for alternative sanctions, or COMPASS, used in the United States, should be mentioned in this regard. In the United States, some states use this system to make risk analysis and use this analysis for sentencing people. For instance, in Loomis versus Wisconsin, the Wisconsin Supreme Court hold that if used properly, COMPASS risk assessment at sentencing doesn't violate the defendant's right to a due process. In this case, the defendant had been found guilty, attempting to flee a traffic officer and operating a motor vehicle without the owner's consent. In its ruling, the first instance court stated that the defendant is identified through the COMPASS assessment as an individual who is at high risk to the community. And it ruled out the probation because of the other factors and the risk assessment tool that have been utilized, suggesting that the defendant is extremely high risk to re-offend. As you see, the COMPASS system exemplifies Kant's warning against instrumentalization. It reduces an individual not to the sum of their choices and potential for rehabilitation, but to a statistical probability derived from data points, treating them merely as a means to the end of risk management. On the other hand, let's give another example from Germany. In Germany, the Federal Constitutional Court found legislation which enabled police to process stored personal data through automated data analysis or automated data interpretation unconstitutional. As these regulations cause interference to the rights and freedoms without the concrete danger required by the German Constitution, the Federal Court found them contrary to the general right of personality in conjunction with human dignity. Another example from the US, there was a lawsuit in which the plaintiffs alleged that their rental applications were rejected due to the site rent score derived from an algorithm-based screening software called SafeRent. In this case, the plaintiffs claimed that the SafeRent scores were based on certain factors that disproportionately disadvantaged African American and Latin rental applicants. It's worth to say that the case is resolved by an agreement between the plaintiffs and SafeRent, and that company actually accepted to pay a certain amount of compensation, and it also promised to make changes in its algorithm while decision making. There are also cases in which state employees complain of being fired because of the evaluation of automated decision making mechanisms. In this regard, we can also cite Houston teachers' case, who claimed that their procedural due process rights were violated, and they also won their cases. As another example, we can also cite the Dutch child care benefits scandal as an example in which the Dutch tax authority accused thousands of parents of making fraudulent benefit claims and requested them to refund their allowances. In this case, the Dutch tax authorities relied on an AI algorithm that led to the wrongful accusation of many citizens, and most of these citizens had dual nationality, actually, and they accused these people of benefits fraud. Here, the reveal of the discriminatory use of algorithms in the allocation of child care subsidies also resulted with the resignation of the Dutch cabinet. And this case demonstrates actually a profound failure to respect human dignity, treating families not as ends in themselves, worthy of individual assessment, but as data profiles to reflect, and instrumentalizing them for the state's goal of fraud detection with devastating consequences. The examination of these problematic cases, from biased sentencing tools to discriminatory housing algorithms, necessitates a robust framework of possible solutions to realign algorithmic governance with the constitutional mandate to protect human dignity. First, transparency and accountability in AI governance are inevitable requirements for safeguarding human dignity. Transparency could be guaranteed by explicitly acknowledging AI users that their data will be used for certain missions. AI governance must also include different stakeholders from the different segments of society, and this requires more democratic public spaces for inclusive decision-making to conform with the human dignity. In addition to the ex-ante controls, there should also be periodic reviews run by independent third-party entities, focusing on assessment of the use of data collected from AI users. In this regard, the results of these reviews could be accessible by the public, thus proliferating the level of the accountability. In order to decrease the risks of algorithmic decision-making, humans' AI collaborated decision-making process could be preferred instead of full automated mechanisms, guaranteeing meaningful human oversight. And this could also optimize the accountability. Human dignity also requires effective remedies to be used against algorithmic decision-making processes. Administrative and judicial mechanisms, independent bodies like ombudsman or commissions should be established with the power to investigate complaints and redress the complaint. When we look at the current regulatory framework, algorithmic decision-making is generally subject to three groups of regulations: data protection laws, non-discrimination laws, and human rights law. But it would be appropriate to note that the first two of these are also part of the human rights law in a broad sense. All the many states have regulations on the protection of personal data. It's beneficial to establish specific rules for algorithmic decision-making. This is because this mechanism constitutes a novel field where traditional data protection rules are insufficient. From a constitutional perspective, while there may not be a need to introduce new regulations specifically for algorithmic decision-making, it's imperative, as Kant said, that courts tasked with interpreting the Constitution, particularly the High Courts, dynamically make new interpretations required by developing technologies and threats based on provisions such as human dignity and the protection of personal data. In any case, drawing on comparative constitutional perspectives, my presentation concludes that human dignity demands algorithmic systems remain subordinate to human judgments, particularly in critical domains. Constitutional and international frameworks must prioritize the irreducible moral and legal status of the human person over technological imperatives, serving as a vital safeguard against the dehumanizing risks of algorithmic governance in the digital age. Ultimately, the challenge is not to halt technological progress, but to end our most fundamental values into the very code that governs our future. Failing to do so risks not only unjust outcomes, but also the erosion of the very concept of what it means to be a human in a world increasingly mediated by machines. Thank you very much for it.
Thank you very much, Professor Aslan. It was very interesting, this speech too, and obviously your answer to the fundamental question is rather optimistic if we take the measures needed, obviously. So we shall have the time to have some questions at the end of the panel. So I pass the floor to Associate Professor AKDENİZ about reshaping the recruitment process with AI and the new problems it will be as discrimination by algorithms.
Dear professors, colleagues and students. First of all, I would like to take my to express my gratitude to the contributors of this organization. It's an honor to participate in the 69th meeting of International Association of Legal Science. As you see in the title of my presentation, I will focus on algorithmic discrimination in the recruitment process. As in the title of my presentation reflects, I will start with criticizing myself. We tend to talk as if the algorithms were discriminatory, but we should not miss the point that the AI is only discriminatory in a proxy way. It is important to emphasize that the datasets used by algorithms are created by humans. We will touch on that, but let's take a brief look at the impact of AI on labor relations first. With the introduction of AI into our lives, labor lawyers have also begun to express their concerns on certain issues. These concerns are generally centered in two areas. The first of these is that the use of AI leads unemployment, and the second is that the AI is reshaping labor relationships. My topic is more about the second one. Algorithms are used in many stages, from the beginning to the termination of contract. They are also used in the recruitment process to determine who will see the job advertisement, make preliminary selections from applications, and conduct the interviews. But the use of AI in these steps is highly problematic. It has additional negative consequences, which we will discuss next. But before discussing these new challenges, let's recall the classic features of labor law. This field of law was developed to protect employees. As German lawyers say, a few drops of social oil have been added to this area. Let's consider in the light of protective nature of labor law. When does the employment relationship begin? Is it when the employee starts to work? The answer is clearly no. The protective nature of labor law comes into play even when the job advertisement is announced. So the first stage of the protection is not the moment when the contract is signed. The process begins with the access to job advertisements. Therefore, discrimination through algorithms may occur in this first stage. As we mentioned, AI is used in many stages of the recruitment process, and it has been used for a while now, especially during the pandemic. Video-based candidate evaluation, remote interviews by using new technologies became widespread. Major big companies are particularly using AI to save time and more accurate choice decisions. But of course, it is not just about saving time or making the right choices. In this way, costs of the hiring process are reduced too. Therefore, the use of AI in the recruitment is already indispensable. But at what point do the job seekers start to face risks? When it comes to selecting the candidates, we are aware that their social media accounts are crucial. They are marketplaces and profiling areas. It has been observed that job advertisements are often targeted at a specific gender. For example, if there are more men than women in management positions, the announcements of this kind of positions are not displayed on female candidates' social networks. I would also like to mention my own experience. While I was preparing for this presentation, I also visited some job matching websites. I didn't apply for anything, but I was just surfing, and after these visits, some offers appeared on my screen, and they were for babysittings. Similarly, when I'm receiving ads for becoming Uber drivers, the point I want to make is that algorithms associate certain jobs with certain genders. Let's give another example. As you know, labor law provides parental leave, and female employees use this leave more frequently than male employees. They are therefore absent from work for a period. If AI prefers candidates with no interruption in their professional career, AI can analyze and predict information that isn't given to it directly. So discrimination can occur even when the employer or the programmer does not intend it. This type of discrimination is not easy to detect. If the database that feeds the algorithm is biased, the algorithm itself may also be biased. If this data contains preconceptions that already exist in society, such as gender, such as age, ethnic origin, AI reproduces them in its own decision-making process. The huge amounts of data used by algorithms in the decision-making process can be a convenient tool for concealing discrimination. This is why AI is often described as a black box. The decision-making process of algorithms is difficult to understand. It is particularly difficult to determine who is responsible. But how compatible is to leave the candidates unpredicted against the new form of discrimination? Can we consider AI just a technological tool or an engineering issue? This approach will be not consistent with the principles of labor law, so it cannot be left unregulated. But you may have some questions at that point. Wasn't there an issue of discrimination even the recruitment process was carried out entirely by humans? Yes, certainly. Employees were able to discriminate without using AI. However, the scope is here wider. Many companies use the same or similar software for recruitment process. And using the same types of software can lead to spread discriminatory practices. Plus, even though the burden of proof for discrimination has been eased, proving algorithmic discrimination is very difficult. Therefore, an accountable system needs to be established. We need to develop a legal system that works for these new risks. The ILO recommends a method in its report, which calls the future of work. According to this, if AI is used for hiring process, final decisions made by people should be made by people. This approach may be also useful in the context of liability law. Indeed, it is also advisable to enact a specific law to determine the responsibilities of the producer, of the user, etc. And it is also important to develop a legal framework that addresses privacy issues. Various legal frameworks have already begun to emerge. In the US, there are state-based regulations regarding the use of AI in recruitment. We cannot mention all of these regulations, but we see that various methods are predicted to prevent discrimination. In Illinois, for example, demographic data must be reported after AI is used to analyze the race and the ethnicity of hired applications. And in New York, a bias audit must be conducted before AI is used. On the other hand, the European Union takes a risk-based approach. According to the European Union directive, using AI for recruitment is considered high risk. There are many obligations relating to high-risk systems. From the perspective of Turkish law, we don't have a specific regulation regarding the use of AI. The real difficulty seems to be proving discrimination and determining who will be held responsible for it. As mentioned, technical and complex nature of algorithms makes them difficult to understand. Although determining liability is necessary, it is certainly not easy. But in every area of law, there are situations so complex and we struggle to determine the liability. Such complexities are nothing new to us lawyers. I am a labor lawyer, and these difficulties of algorithms reminded me of the difficulties of occupational diseases. I couldn't help but think about occupational diseases because determining who is responsible for occupational disease and proving it is such a complex process. If an employee suffers from breathing-related relating disease. Let's say lung cancer. Is it because employee smokes, or is it because of a genetic tendency, or is it because of the work he or she does? These are difficult questions, and we use the causality theories to answer them. But the most important step in dealing with occupational disease has not been taken by determining who is responsible. The real dealing way was through prevention. Prevention is just important as compensation when it comes to dealing with occupational diseases. Now let's go back to the topic of algorithmic discrimination with this perspective. What is to be done? Firstly, machine learning can be developed in a fair way. This can be achieved by incorporating some features like data privacy, accountability, transparency. Incorporating right features into the algorithm can prevent discriminatory tendencies. Secondly, a preliminary check can be conducted to determine whether AI's algorithm is sufficiently fair. Naturally, this check should not be left on the decision to the developer or the user or the employer. It should be regulated in detail. And the audit should continue even after AI algorithms begin to use in recruitment. It is important to check how does this distribution in employment look. For example, has the proportion of female employers hired decreased? This should be analyzed. Checking periodically after use is very important to see if systematic discrimination occurs. Systematic discrimination focuses not on proving what is discriminatory during the operation. The focus by systematic discrimination is whether the algorithm consistently and systematically discriminates against one or more social groups. The systematic discrimination approach is also useful in situations where discrimination by AI cannot be proven. In conclusion, it is clear we are unable to stop the technological and developments from happening. However, there is a need for a legal framework which does not compromise the fundamental rights. This new framework should focus not only on establishing the responsibility, but also on prevention. For these reasons, algorithms used in recruitment should be checked to ensure they are fair, both before and after they are put into use. This approach would also be consistent with the protective nature. I appreciate your attention. Thank you very much.
Thank you very much, Professor AKDENİZ, and thank you for not allowing me to show my strict face and for giving you a warning, a time warning. So it was very interesting, and there is a connecting point between your two presentations because Professor Aslan had spoken about non-discrimination, about network-based being obstructed by algorithms, but on the other side about discrimination by algorithms, and you expanded on this issue, which was very interesting. And so we hope we have 10 minutes or something, 10 minutes of discussion. So please, if you have any questions, please introduce yourself and ask either separately or all together, whatever you prefer. Yes, please, Professor Paris.
Yes, thank you very much.
And let me.
Thank you very much, my guest. Question is aimed to the three speakers. It's an invitation. We see the example of the Council of Europe where collegiate or collaborative efforts are put forward. I would like to raise you reflect more on each of your presentations. What else could we do as a society, as a group, to try to, and I mean with a group and a society, I mean legal scientists, and focusing into them. What could they do together to try to work towards not only adapting, but also anticipating, maybe anticipating the changes that will come. Because I think with the previous session, in which one of our speakers, Stefan, pointed to things that happened 6 or 7 years ago, it's a completely different universe. So it's an invitation to reflect on that. Thank you.
And before your answers, let me take the chance and say, because Professor Elina did not say that he is the Secretary General of the International Association of Legal Science, and I have the pleasure and the honor to collaborate perfectly with him. Thank you.
So thank you very much for your question. Actually, there might be lots of diverse answers to this. And yes, we generally talk about the regulations accepted on the level of the European Council, because the standards set by the European Council are also the things that make us more closer. Our societies are more closer. When you compare the Turkish society with other ones in Europe, there are lots of differences. And these differences also reflect the governmental type of these societies, the legal rules of these societies, or the priorities of the societies. But I think the way to anticipate, to participate in it, this might be not as easy as the old concepts we faced to. As you said, these issues are not very easy to understand. Even when I was trying to prepare my presentation, I had to spend lots of times. Because yes, I have some ideas about the human dignity, but when I tried to implement these requirements of this dignity to the technological developments, it took lots of time. Why? Because I had to study. So yes, I defend the participation of the society, but first of all, we have to create a climate in which that participation could be possible. And in my opinion, that could be done by the civil society actors, especially the civil society organizations which has special interest in these technological developments or AI. They can just analyze the ideas of the people, or they create the tools by which the society can just actually participate in the decision-making processes and rule-making processes regarding these issues. And unfortunately, it's not very possible to find a common ground all the time for all the civil societies regarding this issue. And the levels and the sources of the civil society organizations are not, as they say, for example, not same in Turkey, not same in Germany, or etc. So one of the biggest problems in Turkey we have is here our civil society organizations are not so powerful. They lack lots of sources, financial sources, human sources, and etc. So in my opinion, yes, we talk about the general regulations made by the European Council, but when we talk about anticipating and making people participate in this decision-making processes, it's not very possible to find a unique way that is applicable in all Europe. We have to find solutions in each country, in European countries. In Turkey as well, the solutions we find will be probably different than yours in your society. That's my opinion. Because this is very, let's say, difficult to understand this concept and this developments. But I don't know if
Thank you so much for the presentations. I'm Professor Elina, fourth-year student here. My question was to Professor Kaya. You talked about the framework within the Council of Europe, but you mentioned the framework is not intended to be implemented against the private actors. My question was about AI in today's world is mostly used with the private actors. The public actors are not actually within the AI, I would say, department right as of right now. But with the exclusion of the private actors, then this makes the framework really not in the greater application. So can you talk a little bit about how we can use AI, we can use the private actors, and how we can implement that they are within the human rights problems?
Thank you very much for the perfect question. Due to the nature of international treaties, obligations are only put on parties, and parties, by definition, either states or international organizations. This doesn't mean that the exclusion of private sector doesn't put any obligation on states, because the general nature of international human rights law requires states to implement and to honor international human rights law standards. Although no convention could put an obligation on a private sector or on a private entity, still states are under an obligation to protect, to fulfill their human rights obligations through their internal domestic laws and regulations. As you know, as you and me pointed out, AI systems are produced, developed mainly by private actors, and sometimes private actors are more powerful than at least some states. And this is obviously a problematic issue, not only in AI sector, but in a corporate world, in other sectors too, in telecommunications and environmental protection, and I may give plenty of other examples. In the world we live as of today, in the AI sector, there's a race going on not only among states, among nations, but also among private sector companies. And some states believe that if they employ or adopt a restrictive approach, they'll stay backward compared to other states. But on the other hand, a more liberal approach may harm the human rights of their citizens. So a more balanced approach is needed, and any legal document, including the Council of Europe's Framework Convention, is a compromise among competitive interests, and this tries to balance, on the one hand, the technological advancements, and on the other side, the protection of human rights. This might be my answer. I'm fully aware that this is not an ideal document, like any other legal instrument, but this is what we have at the moment. Although I mentioned we have 16 state signatories to the document and the European Union, none of them has been ratified the convention. So there's a challenge ahead. Thank you.
The number of the panel is fundamental rights. Yes, and the protection, the protection of fundamental rights. So I have a provocative question. If human rights, fundamental rights are not the objective phenomenon, it's evolving phenomenon and based on the values of the general idea of values development and the uniqueness and specific of every society, every culture, every religion, every tradition. Are any decisions of IE in principle compatible with mathematical logic and so on, with with solving social problems and protection of fundamental rights.
Thank you very much for the question. Of course, everyone has different perspective regarding this question, but my perspective is we always have this problem between the universal claims regarding the human rights, but also there are some, local elements which affect the implementation of these rights. For example, in European level, we can mention about some European standards regarding the human rights. That's why we are all actually recognizing the competence of the European Court to review our acts, whether they are compatible with the Convention or not. But regarding my human dignity issue, as I said, human dignity is even regulated in non-liberal constitutions like China. And we always accept that the human rights, maybe not all of them, but to a certain point, some of the human rights are universal. Or scope of these rights differ in different regions, but we can still find some universal values. And human dignity is very important, I think, key to open this universal regarding the law and the AI. So I think all the cultural or regional differences, we can find some common points that are valid for all the countries in the world. And that values actually can shape the relationship between the humans and the AI. For example, in my opinion, automated decision-making could be accepted as contrary to the human dignity in all the countries in the world, because you lack human decision here. And a machine makes a decision on your, it makes a decision for you. So, in my opinion, that value could be accepted as a universal value, etc. So, maybe the United Nations might be a very important tool to, make the countries accept what are the universal standards regarding these issues, because the United Nations is the universal organization. And it did some conventions with this. For example, Convention on the Rights of Child. Its protections and its guarantees are accepted by all the countries in the world. So it's possible, I think.
It's not an example, it's an exception.
But why not more?
It's a difference.
But we can have more exceptions.
I may reflect on this question as in that we call it, it's a universality of human rights issue and different values, but at least all human beings share the same values as human rights, human dignity, AI or human rights, security or human rights, food or human rights, but without human rights we cannot have any security. Without human rights we cannot have right to access food. Without human rights we have no right to access to AI. So without law, without human rights we cannot have anything. So the basis should be human rights. I am fully aware that we are not living in an age where human rights are so popular, but if we start to compromise for human rights, we will have nothing left, I guess. This is my point. Thank you for the question.
Thank you. I would like to make a small question to each one of you, and let me say that it is not, in my opinion, it's not the fact that human rights, it's not so much that the human rights are protected or not, but sometimes it's the interpretation of the human rights, so that's what gives the floor to random treatments and everything, but it's a huge issue. But in general, you spoke about the signature. So, I mean, I see that they need, the convention needs 5 ratifications, at least 3 member states of the Council of Europe. Isn't that usual? And then standard for the Council of Europe's conventions, because nowadays, the number of ratifications needed is lower. So why the 5? If you have some idea, or if it is a standard. Perhaps I should make all 3 questions.
Yeah.
And then, okay. And a question to Professor Aslan. You said that USA has no explicit provision about human dignity, but it refers to decisions. It mentioned the decision of 2015. Is it a decision about AI, or is it a general decision about human dignity? And was there not any formal decision that leading case, for example, considered as leading case? And what about the state constitution? Will they refer, if you have some idea? And something small that perhaps a little provocative. Okay, discrimination by algorithms will be handled if it will be denounced. And if not, what will happen? Should the states take measures to learn somehow about this discrimination? Because sometimes people are afraid to denounce discrimination for several reasons. These are my questions.
All right. 5 ratifications, 3 of them Council of Europe states for the convention to enter into force. The threshold is low, and we live in a very fast world, and this is not a very difficult number to reach. Nowadays, this type of treaties require small numbers to enter into force. Once a treaty enters into force, other states may decide to join it. So it's a kind of carrot, you know.
I meant that, for example, something you can do it's another treaties only ask for 2 ratifications, which is too low. But perhaps it's
2 or 3. I mean, in this case it's 3, 5, but 3 from the Council of Europe, and it's good.
Thank you.
Thank you very much for your question. The case from the US Supreme Court, actually, I cited this case. That was not about the AI. Actually, it was 10 years ago, and I just want to give it as an example to show that even though your constitution doesn't explicitly regulate this, you can still use human dignity as a criterion to evaluate the constitutionality of the laws. And here, for example, right to marry is accepted as a requirement of human dignity in the US Supreme Court for all people. That's why actually I have cited this. But if you don't explicitly regulate the things in the constitution, it always carries the risk, actually. Why? Because if we regulate it in the constitution, then it might be much more difficult for the legislative branch to change it, because most of the constitutions are much harder to change. And if you don't regulate it in the constitution, then the legislative organ is much more actually free to regulate how it wants. So regulating it in the constitution is always a good idea. And I can just give you an example from still the US, because maybe you remember sometimes the high courts can change their jurisprudence. Why? Because this issue is not, the Supreme Court. And why? Because this issue is not explicitly regulated in the Constitution. So, this is the point. Actually, I haven't checked the specific state constitutions, but I will. So, I will also check the 50 state constitutions to check whether there's explicit reference to the human dignity. Thank you.
At the beginning, people believed AI is much better than humans because it will be objective, but then we learned that. And now we are facing the new problems. I believe like with the new concepts like systematic discrimination, we can handle it, but we will not. There is no 100% solution.
So, thank you all. We think that it is time for a break. Become break.